Well, we've established that trials are the least common outcome in the American legal system. They are still worth considering as they can be extremely consequential. Many big cases with severe charges do go to trial, even if it's a small fraction of all the cases that there are. One thing that makes American trials somewhat unique compared to other times and places in history is the use of the trial by jury. And this jury system has its roots, like many of our legal traditions, in England. And the first juries to happen in medieval England actually arose from the need for witnesses. So if a legal official came to some country town or village and was trying to get to the bottom of a case, they would call members of the community who they thought might know something about the case. So they weren't chosen necessarily to be impartial, but because they were people who had greater knowledge and could testify and come to a decision about the case. But as the system evolved over the hundreds of years, you reach this point sometime around the 1600s where the jury goes from being a group of informed witnesses to independent decision makers who decide the outcome of the case. And the role of the jury gradually expanded in English and then later American law. And we've talked before about how juries differ from judges and other legal officials, being a cross-section of the community, being chosen not because of their high education and high social status, but just because they're ordinary people. They tend to be lower in status than judges and other legal officials, and therefore, as settlement agents, they tend to be less authoritative, less legalistic, less prone to punishment, more prone to compromise, and more prone to deviate from the written law. And this happens so often that there's a term that legal scholars use, jury nullification. And the idea is that the written law can be nullified by juries who refuse to apply the law as it's written. And this has actually wound up being an important source of legal change. For example, free speech laws in the US, as we understand them today, have their roots in jury nullification. In the colonial period, the written law said that you could sue somebody for libel for printing something unflattering about you in a newspaper, even if what they printed was true. That is, it could be a crime to ruin someone's reputation with true information about what they did. And so you had a case where somebody was bringing charges against somebody else for publishing something in a newspaper that they said harmed their reputation. And according to the written law, the person who published the harmful information should have been found guilty. But the jury said no, that he printed the truth. We're not going to vote against this guy and convict him for printing the truth. And so the jury just refused to apply that law. And this decision and ones like it set a precedent, a strong precedent in American law, that it's not a crime to say something about somebody that's true, even if it harms their reputation, and you can't sue somebody for printing the truth in a newspaper. So the reading for this section is by a legal scholar named William Pesey, and it's an analysis of the American trial court system in comparison to the trial court systems in some other Western countries. And I'm not going to go into extensive detail about what he writes, you can read it for yourself, but his basic argument is this. Compared to other Western countries, U.S. trial courts are relatively more formalistic and relatively more adversarial. And we've went back and forth on this idea of formalism because we have critics complaining that American law is too formal, and we have other critics like the legal realists saying it's actually not that formalistic at all, and so which is it? Make up your minds. Well, solving that apparent contradiction requires realizing that formalism is a matter of degree, so whether American law is very formalistic or not very formalistic really depends on what other legal system you're comparing it to. And B, it's something that varies from case to case and across different levels of the legal system. So some courts and some cases are handled more formalistically than others. What Pesey means when he says American law is very formalistic is he's thinking of things like the exclusionary rule, which was established in 1961 in the case of Mapp versus Ohio. And this is the rule that any evidence that the police gather in violation of rules regarding search and seizure, so if they gather evidence, say, without a warrant, they can't use that evidence in court to convict you of a crime. And the reason for this ruling is to help enforce rules against unreasonable search and seizure to protect individuals' rights to privacy and freedom by removing an incentive for police to tap your phones without a warrant or to search your house without a warrant. The idea being if they can't use this evidence against you, if it's not gathered legally, then they won't go out and gather evidence illegally. But Pesey says there's a darker side to this rule, and that's that it encourages a concern with procedure over truth. So this is one way in which a trial might be less concerned with the truth of whether a crime was actually committed, what a person actually did or did not do, and more concerned with the procedural rule of, okay, was this evidence collected according to the letter of the law? So while many of us would view this as a good thing, Pesey is critical of it as an example of a high degree of formalism, and in this respect he might be similar to Roscoe Pound. He also talks about American law being more adversarial than the law of other European countries, which of course is something that's rooted in English legal tradition, but he says we're even more adversarial than England is nowadays. And he gives some examples of that in his discussion, things like how US judges are much more passive than European or English judges, and they kind of tend to sit there and let the prosecutor and the defense attorney run the trial. And so rather than a sort of fact-finding session where the judge is trying to get the information from the attorneys, it's more like a competition between the attorneys to shape the facts to their own side's benefit. And he points to all these different ways that attorneys play a much larger role in American trials. Compared to Europe and England, U.S. trial attorneys are more closely identified with their cases. Their individual reputation hinges on the outcome of the case to a greater extent than in other systems. For example, in England, there's a distinction between solicitors, who are the attorneys you hire to get your case filed in court, and barristers, who are the attorneys who actually argue the case in court. And so if your case loses, the solicitor could always say, well, I wasn't the one who argued it, so it's not my fault. And the barrister can always say, well, I'm not the one who accepted that case and thought it should go to court. It was an unwinnable case to begin with, so it's not my fault. And so there's less of a strong incentive to go all out. He also points out that it's unusual cross-culturally for each side to have its own independent investigation. The prosecution working with the law and the defense attorney during their own investigation. And so you'll find things where there's expert witnesses on both sides, and both of these supposed experts are saying opposite things about what the evidence says. And you could have one side having access to information the other side doesn't have access to, and calling surprise witnesses and stuff like that. And he says in American trials, attorneys take a more active role in shaping the evidence from the get-go. They can do things like hire experts and coach witnesses in their testimony and say, okay, wear this, say that, don't say that. He even mentions attorneys having an emphasis on performance and doing things like trying to alter their cultural appearance to fit in with the local culture of the jury. So if one experienced attorney said when he tries a case in the Bible Belt and heavily Christian communities, he wears a lapel pin with praying hands on it to make himself appear to be a Christian, or at least more faithful than he actually is. So he'll blend in more with the populace, and that cultural closeness will help his side win. And to PZ, that's something that U.S. attorneys do more than attorneys in other countries. Have an emphasis on just win the case, whether it's the prosecution just wanting that conviction and, worrying less about whether the defendant's actually guilty and deserves to be punished, or the defense just wanting that acquittal and worrying less about whether they're getting a guilty person off the hook. And you might think this balances out, or maybe it's a good thing. If I hired an attorney, I would certainly want my defense attorney to be trying to win my case as hard as they could. Just like if somebody killed someone I love, I would like the prosecutor to be trying to win that case as hard as they could. But PZ argues that this has negative consequences. This just win attitude and all this power the attorneys have to shape the case, either as prosecutors or as defense attorneys, leads trials to become a costly war. It leads to things like scorched earth tactics and attempts to sabotage the legal outcome. And it makes trials such a costly and potentially disastrous mess that this feeds back into our system of plea bargaining. Because trials are such a all-out war with both sides trying to win, often by whatever dirty tricks they find necessary, it makes the outcomes less certain, it makes the process more expensive, and it leads to the greater incentives to plea bargain, and greater incentives for prosecutors to try to make plea bargains by overcharging the defendant. And so you get these ridiculous outcomes where prosecutors bring charges that seem completely out of proportion to the actual crime in an attempt to force a plea bargain and avoid all the cost of a trial. And so you get something like this case that happened several years ago in Pennsylvania, where like an angry wife found out her husband was cheating on her with another woman, and as a little bit of revenge, smeared the woman's doorknobs with some kind of household chemical like lye or something like that might have, burned her hand or given her a slight discomfort. And she was prosecuted under international chemical weapons bans meant to combat chemical terrorism, and a lot of people were critical that this law was clearly not intended to apply to smearing some household chemicals on the doorknob of the person your spouse has been cheating on you with, and pointed out how this is an example of prosecutors just stretching the law to bring the most severe charges possible in order to cause people to knuckle under and plead guilty and avoid that costly trial.